here for oral argument in Berk versus DiMarco, our case CV19-0424FC. Counsel, each side has 20 minutes for oral argument today. Appellant Ms. Woods, if you wish to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time. If we were in the courtroom, there'd be this delightful podium clock that you could use. Instead, I have kind of a rough sort of phone timer that I'll keep track as well, and I'll let you know after your initial argument how much time you have left for planning purposes. When you're not speaking, we'd encourage you to put your microphones on mute so we don't get feedback. Sometimes that complicates things. We have reviewed the record. We've conferenced the case. We would encourage you to keep that in mind as you do present argument. Arguments are being recorded and will be posted in due course. So please, as you begin your argument, if you tell us your name and the party that you represent. With that, Ms. Woods, you may proceed.
Thank you. This is Chloe Woods on behalf of appellant Jennifer Berk. And the matter that we are here on today boils down to just a few facts that we want to really reiterate. That Ms. Berk is a former professional tennis player with limited employment options in Arizona. Ms. Berk has a high school education. She's currently unemployed and does not have stable housing or reliable transportation. However, Ms. Berk has a full-time job, a salaried position with healthcare awaiting her in Kansas City, Missouri, that will properly compensate her for her skill and experience in tennis. Previously, Ms. Berk temporarily relocated due to those emergency circumstances of being homeless and unemployed. In changing her prospective destination, the Superior Court found Ms. Berk's contention that relocation would be in her daughter's best interest was undermined by the previous desire to relocate to Florida. However, the same circumstances that were present at the time of her emergency relocation, they persist today. She has unreliable transportation, she has lack of stable housing, it's unemployment that she's facing. These circumstances affect Liliana's emotional and physical well-being, yet would be immediately ameliorated if this court permitted Ms. Berk's relocation request. So what we would like the court to take under consideration today is that the court erred by finding the proposed move would not improve the child's quality of life, and thus finding that the prospective advantage factor weighed in favor of the father. We also, another issue.
But counsel, we weren't there at the hearing. The trial judge was. What makes our judgment of the circumstances better than the judges?
At the time at the trial court, the court didn't make any specific findings and made very conclusory statements. So without having that further consideration and without having something instructive for both the appellant and for the court to look at, we feel that those statements were just conclusory and didn't give a proper weight to the evidence that the appellant presented.
Well, counsel, did you ask for more detailed findings below?
I did not represent Ms. Berk at the trial court level, so no, I did not.
Well, but did the trial counsel?
Not to my knowledge.
And counsel, what findings are you claiming were deficient? What more needed to be done?
One thing was that the father's relationship, essentially the father's relationship, yes, although important, it shouldn't trump the mother's ability to move and to improve her circumstances, which would presumptively improve the child's circumstances. So much weight was given to the father's relationship with the child, the characterization of the testimony of the witnesses, and that would be found at page 4 and 5. The witnesses testified that Mr. DiMarco was a good dad. And so we're not disputing that, but what does that mean? That he sees her every other weekend, that they spend time together? Those factors shouldn't trump my client's ability to move and improve her situation.
And I understand that argument, and you're that argument to me is that the trial court should have weighed the evidence somewhat differently than it did, and to Judge Howe's question, that's not really what we do on appeal. But let me ask about the findings, because I do view your brief as challenging the adequacy or the sufficiency of the findings. And looking at the minute entry, and you mentioned page 4 and 5, I mean, it seemed to me to be a fairly detailed minute entry. And that's why I wanted to know, to better understand your argument about what additional findings were required.
Well, on page 5, well, the factor under 25403, the court didn't spend enough time on was which parent is more likely to adhere to like the order. And I thought that was somewhat conclusory there. We give the fact that she changed her, and then also we give the fact that she changed her position from Florida to Missouri. I thought that was given a lot of weight, but it seems not the location, the prospective destination, I won't say it's irrelevant, but the motivation is the same. So if the motivation for her wanting to relocate and all of the issues that previously persisted or previously were present continue to persist, I felt that was the wrong determination as well.
Well, counsel, when you say it's a wrong determination, that sounds awful lot like the court weighed everything incorrectly. Not that the nature of the finding was insufficient, the finding's wrong in your view.
Well, I guess I should have said that not the wrong determination. I found that was a conclusory statement without actually going through any. The rationale was that her desire to move to Missouri for a better opportunity is undermined by her previous desire to move to Florida. That was actually like what was written. So I felt that was conclusory, because how is it undermined? The factors are still the same. The factors that require her to prompt her to want to relocate are still the same.
So are you asking that we remand for better findings?
Yes.
It sounds as though the trial court concluded that mother's desire to move was basically, the argument was that anywhere but here is in the child's best interest, and that seemed to weigh into its thinking, whether we agree with it or not. I'm wondering now, that order was a year ago-ish. And you tell us that your client is still homeless, still unemployed, but has a full-time job offer that somebody's been holding open for a year?
Yes, that's correct, Your Honor. So she did have a position. She was hired in some retail work at the beginning, a couple months prior to the start of COVID. She lost her employment during the COVID-19 when things were shutting down. So that factor is still present at this point. The owner of the country club in Kansas City, Missouri, is still holding this position for her and holding it open. It's a country club that has tennis courts on the premises, and she would then be there as the director of tennis and kind of leisure for the country club. That position is currently not filled, and they have assured her that they're still holding that position open for her pending the outcome of this. And
you say she's homeless. Where does she live?
She lives in a room with a neighbor. So she and her daughter are sharing a one bedroom in a neighbor's home. She previously did go to her parents' home, so the grandparents that testify in this matter, but they said they just don't have room. They didn't have room for 2 additional people.
Okay. You say a neighbor. I don't mean to be crass, but a neighbor of whom? She's homeless.
Correct. Her former neighbor.
Okay. And so everything's been static for the last year, just waiting for this argument, you're saying?
I wouldn't say everything has been static. She's been continuously seeking employment, and she did get an opportunity that she was working in retail. So I think she's still trying to make the most of the situation. The owner of the country club has said they would hold this position open. It's a position that they I don't want to say created specifically for her, but it was a position that came about, and they had been looking for someone. They met her, they interviewed with her, and really liked her, and so hadn't had anyone else fill that role or anyone else they really liked for the role. So I don't want to say static. I think things have been difficult for her throughout this time. She's been attempting to better her situation, but has lost the recent employment that she had due to COVID.
I see. Okay, thank you.
Thank you.
Ms. Woods, do you wish to reserve the remainder of your time, or do you have further argument that you'd like to present at this time?
I would like to reserve the remainder of my time.
Very well, and I have you having about 10 minutes and 45 seconds left for rebuttal. Mr. Hoxie.
Good morning, Your Honors. May it please the court, my name is Matthew Hoxie. I represent Respondent Appellee Mr. DiMarco. We respectfully ask that, given the deferential standard of review in the court's findings, that this court affirm the trial court's order denying Ms. Berk's petition for relocation. Both Mr. DiMarco and Ms. Berk are devoted, caring parents, I think as both sides recognize, who reside in Arizona. The child resides in Arizona as well, has friends and family in Arizona, goes to school in Arizona, indeed has her entire life here. These were the facts that were before the trial court. And it is for these reasons that while Ms. Berk believes relocation is in her best interest, relocation is not in Liliana's best interest, as a Superior Court found. I take the position of opposing counsel to be the same as yours, Your Honor, Judge Thama, that it's challenging the specificity of the findings. The court followed the statutory required findings or factors under 25408 and 25403.
Did it follow Owen v. Blackhawk? I mean, Owen requires basically a novelette about the interrelationship between the factors under 25408. And while I would agree that there were certainly more findings than you see in a normal custody dispute. Can we say custody dispute anymore? But more findings than you see there. The description of the interrelation requires a little bit of inference from the reader. Would you agree?
I think that's a fair understanding of it, but I don't think it's an unwarranted or unreasonable inference. It's one that follows closely from the facts and the detailed analysis provided. I think the court's order builds on itself, so the later findings or later factors in some ways relate to evidence previously discussed. If the court looks at page 4 and 5 of the order, those are potentially the most thorough pages, but provide a lot of the background facts and evidence that was provided and the testimony that was also provided. Giving credit to the fact that Miss Ecker, who is father's partner and had the mother of his child, or his other child, shares a relationship with the daughter, helps her with her education issues. Page 5, where it notes that father was a good dad. And discusses his relationship with family and friends and his involvement in the community along with Liliana, where it notes that, page 6, page 7, that while mother discussed her relocation request to Missouri, she did not provide details or specifics about the nature of those friendships. Though she initially said the child has friends in Missouri, and cross-examination, she acknowledged the child does not. On page 8, where the court noted that the parties both testified, the child has a close relationship with mother's family in Arizona. She has a number of close friends in Arizona. So I think it was a kind of building of the court's order throughout that as it considered the factors leading to its ultimate conclusion that relocation was not in the child's best interest. I'd like to point out that I think mother makes a slight shift in her argument between her opening brief and her reply. Her opening brief frames the issues as being, lack of specific findings. Then in her reply shifts to challenging the weighing, which, as Your Honors correctly point out, is deferentially reviewed, and of which there was more than sufficient evidence and no errors of law. In that case, or because of that, this case is very much unlike that of Owen and Hurd, where there was just a lack of specificity of findings and a lack of detailed analysis that the Court of Appeals on review just had no way to determine or no measure to determine how the court actually balanced those factors. And I think in Owen v. Hurd, there was too much or the only factor that was primarily discussed was the effect that relocation would have not on the child's best interests, but on the father and his relationship. Here, to the extent that the court considered father's parenting skills, it was in light of the child's best interests, which is the guiding light in all these proceedings. Mother challenges that the court did not fully consider the prospective benefits or looked into the physical, emotional, and mental well-being. But once again, there was sufficient evidence presented by father that the child remaining in Arizona was in the child's best interests. The court, I think mother's argument is that the court punished her for changing her relocation request from Florida to Missouri, which is just not the case. The court noted it as somewhat unusual because it was not clarified to the court until page 35 of the transcript that mother was actually seeking to relocate to Missouri instead of Florida. Exhibits that she provided evidenced or related to Florida, related to her place of residence there, her potential job there, her boyfriend there, which are just irrelevant to the determination as it applies to relocating to Missouri. In regards to Missouri, there was simply a lack of evidence provided by mother substantiating that it would be in the child's best interests. As to whether or not the court properly considered father's relationship, again, I think it did, but in the context of the child's best interests, having the child remain in Arizona does not prevent or inhibit mother from moving to Missouri to better her career. Indeed, she may. It just does not mean that relocation is in the child's best interests.
And do you take issue with the representations made that mother is currently homeless?
I would, given that she has a place of residence to currently reside. I understand that she does not own it, but certainly she has a place to stay. One, I think, important thing to consider, though, is that, and it may have been you, Your Honor, Judge Swan, or Judge Howe, that noted that essentially mother's argument is anywhere but here, or anywhere with mother. Father, throughout the proceedings, has offered to house Liliana to help mother get on her feet, get a job, and pursue a career in the tennis industry if she so indeed chooses. He has a room for Liliana. He has a loving home. He can provide her food and shelter and everything she needs. And mother can, if she chooses, decide to relocate. The court established a parenting plan that could be put in place if mother chose to relocate with the child remaining here, just that mother chose, given the court's denial of the temporary relocation and the permanent relocation, to reside and remain in Arizona. There are solutions that mother could use other than seeking to continue to relocate with the child out of state. Again, it's a very deferential standard. The court was there. It heard the evidence. It heard what we attest as a lack of evidence supporting that relocation would have been in the child's best interests. It fully considered all the evidence. This is, in my review, a pretty detailed, thorough order spanning several pages, once again, considering every statutorily required factor. And we think the court should affirm that decision. We think, similarly, that the court should deny mother's request for attorney's fees. In her opening brief, she cited several statutes we believe are inapplicable. In her reply brief, she cites a statute that we think would waive the argument. But even if the court were to consider it, balancing financial resources and reasonableness of positions, we don't think father has taken any unreasonable positions here. This is indeed mother's appeal. He's offered throughout these proceedings to house the child. And I will attest that as to my client, throughout COVID-19, his employment status is intermittently furloughed by his employer. But despite that, he is still meeting his child support obligations. We don't believe that attorney's fees are warranted or applicable, particularly given the pro bono nature of this case. So if the court has no further questions on the trial court's order, the sufficiency of its findings, we respectfully ask that the court affirm that order.
Thank you, Mr. Hoxie. Ms. Woods, rebuttal.
One thing, thank you, Your Honors. One thing that was just made note of is the lack of evidence regarding the move to Missouri. Initially, the mother left on a temporary or emergency basis and then had to come back for the hearing. So all that was presented at that time was the evidence regarding the temporary emergency relocation. And that's why the evidence provided was evidence regarding the move to Miami. So there wasn't anything provided at that point regarding Missouri. And it was because she was trying to, I guess, provide the evidence as for why she met the standard under the statute for a temporary relocation. Additionally, Mr. Hoxie makes note of, again, on page 4 and 5, like witness testimony that he's a good dad. We are not disputing that. Appellant doesn't dispute that there is a relationship with Ms. Ecker. What she takes issue with and what we have contention with is saying that in improving appellant's circumstances and station in life, that the child's standing in life in best interest wouldn't presumptively also be improved. If the mother is doing better, the child will also be able to do better. If the mother has a salary position, if the mother has health insurance that she currently doesn't have in a way.
I understand that argument, but I'm compelled to ask. I mean, it seems that this entire case revolves around mother's insistence that she work in the tennis industry, which is a fairly narrow sliver of the economy. And you know, I've had a few thousand of these cases. I don't recall anyone turning on the desire to work in such a narrow industry. If the well-being of the child is really the issue here, aren't there things mother could be doing?
With a high school education, she doesn't have anything that will pay her or compensate her.
There are a lot of people who didn't go to college in Arizona who are gainfully employed. I can't accept a high school education as a reason to move to Kansas City. There must be something else.
She has looked for opportunities in retail, and is saying that at this time, with what she's able to make with the retail, hourly rate, she's unable to maintain a home. She's unable to maintain a place to stay off of that.
Well, how much would she make as a tennis coach in Kansas City?
This is a salaried position for, I believe, $60,000.
Okay, so $30 an hour, roughly.
Right, and so here she's looking at hourly wages of about $12 and $12 to $14 in all of the retail positions that she's been able to get calls back and interviews for.
In retail, yes, but there are well, I'm not going to turn into an employment consultant here, but there are a lot of avenues other than $12 an hour retail jobs, even if you don't have a high school education. So I'm just wondering what else she might have tried to do, or how the child's interests have really been promoted during the very long pendency of this case.
I know she did try to, or she did, in fact, take some positions that were contractor positions, like as a tennis instructor. Those positions are about $20 to $22 an hour. But again, it's $20 to $22 an hour with maybe 3 to 4 hours within a week. So it's not happening on a frequency that she could actually use that income to maintain a place of residence. It doesn't include health insurance. So those are the other things that she's attempted at this point.
Okay, thank you.
Counsel, Ms. Woods, do you have anything else you wish to add at this point?
No, sir, I do not.
Very well. Thank you, counsel. We appreciate your briefing. We appreciate your argument today. We appreciate your knowledge of the record. It's been very helpful to us. We will take the matter under advisement, and we will issue a written ruling in due course. At this time, the court proceedings are adjourned. We'll excuse counsel, and then the judges will have an opportunity to confer on this and other matters as well. So thank you, counsel. You're free to leave.
Thank you.
Thank you.